Calls case number 19-6462 DM Daryl R. Curtis versus Candy M. Lemke. Parties are in the courtroom. We have motions regarding parenting time, custody, alleged violation, show cause hearing, contempt proceedings. Would you both please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes.
I'm sorry, I didn't hear this.
I do.
Great, thank you. Before we proceed in this matter, again, I would caution both parents, please do not use the child's name. You can use the initial C if you wish to. That's just in respect to the child, so I hope you do that. There's a show cause regarding Ms. Lemke, I'm sorry. There is complaints filed by father for alleged denial of holiday time. And what's going on, Mr. Woolworth?
The parties do have their competing motions, Your Honor. The front of the court have received a complaint from Mr. Curtis alleging denied parenting time. It had been sent to my email on Christmas Day. I did not receive it until after the first of the year when I had returned to the office. So there was a show cause scheduled for an alleged violation of Mr. Curtis's Christmas holiday, as well as him not being notified of medical appointments or medication from Ms. Lemke. That is the basis for the show cause. There is still, Your Honor, an active bench warrant for Mr. Curtis's arrest for failing to appear to a show cause hearing in December. Last I checked, that is still active.
However, I do note in the response by Ms. Lemke, she alleges that Mr. Curtis was arrested on a bench warrant Christmas Eve. No, or did I get that wrong?
I believe that may have been part of a reasoning for an alleged denial, Your Honor. I believe. I can defer to the parties, but the warrant, a notice of warrant would have been issued prior to the Christmas break.
So the warrant was failing to appear on a show cause with the court.
Correct. I'm just checking the notes here. Mr. Curtis had failed to appear for a show cause on December 18th, and the bench warrant had issued for his arrest.
Okay. Well, let's begin with that one. Since we're here, Mr. Curtis, why were you not here on December 18th?
I was unaware of it. I did not get any notification in the mail. I had issues downstairs with district court too, that mail was returned. But my address has not changed in 2 years, so I'm not understanding why that. I found out about the bench warrant through Ms. Lemke. I called the friend of court. They told me it was a $800. I had to pay $800 to resolve the issue.
Did you do that?
Yes, I have a $500 payment, excuse me. Well, there's a $500 payment received, and then I have an online payment as well. That should equal $800.
I would just ask dates on those payments, Your Honor, because our records show no payment since a willful payment since October of 24.
Who did you make the payments to?
Well, one was today to the friend of court.
Oh, today? We wouldn't know that.
Yeah.
What about the other one?
It was online probably a couple of days ago is when I made the online payment 2 days ago.
It may be the SBU processing time with expert pay. So generally, the SBU will see the payments that are routed through the Michigan State Disbursement Unit within 48 hours once they're identified. So if that, for instance, if that payment was made on Wednesday, that should be reflected in our records as after tonight's fax process. So we would see it on Monday. When we return to the office.
What were the amounts online?
What were the amounts, sir?
I believe it was $279. 279 is what I had paid on the the online. For the online, and then I paid cash today at
And how much did you pay in cash?
$500. And the reason being, it's been slow for work and I've been very tight, barely enough to pay my main bills.
Well, regarding the notice. Looking here. I don't want to give the full address, but is the house number 526?
Yes, absolutely.
Okay,
Yes, district court as well had I ended up getting a warrant for them, a bench warrant. Because that it was return sender, so I didn't know if it happened through circuit or.
no, it didn't happen through circuit. I can't speak for district, but I don't think they'd have an issue either. But on October 29th of last year, a certificate of mailing from Mitchell Holdwick indicating that this matter was sent to you by mail at your 526 address. And the support enforcement order indicates it is ordered that you are to appear on December 18 at 1:15. So according to this, you did receive notice. So I don't know if it's the mail, I don't know what it might be.
Right, physically, I didn't receive it.
Okay. All right.
I wouldn't have let it go. I don't skip out on a court date. That's,
I
I'm,
understand.
you know,
I understand. I do find you in contempt for failing to appear. The court will issue a sanction of $800, which you've already paid, and that'll address the matter.
thank you, sir.
Your Honor, just clarification on that. From what Mr. Curtis told me, $500 was today, $279 was online, so.
We're short a little bit, aren't we?
Short. So I'm not sure if the $279 was after the fees were taken off from the online payment, but if this is what was paid, we're still short.
We can pay the balance. I can pay the balance. I can pay
Today?
Is it 21? I can pay it today, yes.
Today. Okay, I'll order that paid today. That's the sanction. That will cover it.
Would you like the receipt for the?
So I'm accepting your word. And Lord knows if it comes back improper, obviously we'll address it at that point. So
Oh,
I'm taking it
absolutely
your word.
not.
So we're fine.
Yes, sir.
All right, that addresses that. Now, you're alleging that you did not get C for your Christmas holiday.
Yes, Sissy was denied. I was denied Sissy's time, December 25th. And it was based on the child support. Guess that's what I'm here today to, because I believe a lot of the reasoning is illegitimate why I'm denied my parenting time, and that's what my concerns are here today through the court, also with other issues.
Do you acknowledge receiving a text from Ms. Lemke, 10:39 a.m. on a Sunday? Send me some money and I won't call the police the day you pick up C. You can at least spend time with her until you get arrested on your own.
Yes, sir, and I called the authorities because I felt like I was being extorted as well, so it kind of actually put fear in me, you know, based on threats and things that, yeah.
Okay.
It's hard to.
But on the other hand, though, you are behind in support.
I am. I'm not denying that.
$1,800.
Currently, as of today, without those payments that to be processed, $1,093.23. If no payments were made by the end of this month, he'd be over $1,300. So with it charging $218 per month as a base obligation, his arrears will be reduced once these two payments are processed. The exact amount, I'm not sure. I could look math on the fly.
Sir, this has been ongoing for years about money issues. It's always money, 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 money. And also I do give her extra money I have through all electronic payments through Venmo, Cash App. She's requesting money for her personal gas. I have,
I did read that in text messages, but let me ask you this.
yes, sir.
Did you send a text message to mother? I want my daughter, Candy, tired of you. You're not even let me talk to her. What kind of bull ass mother does that piece of S? Did you do that?
I didn't call her a POS. I said, what kind of mother does that? Yeah.
What kind of bullshit mother does that piece of shit? That's what you said.
I was upset. She, ever since Celie was born,
Don't use the child's name, please.
she's been trying to take her
Yeah, it
daughter.
wasn't a text, it was a voicemail.
That's what I said, voicemail.
Oh, okay.
Yeah, I said voicemail. I'm just reading the description. So how does that, I can understand being upset, but how in the world does that help the best interest of the child?
How,
No, answer my question.
because it wasn't in front of her. It was through her voicemail and our child did not hear it.
She did.
She did, no,
Excuse me, wait, we're not going.
Sir, if
this
she
is not, wait, this is not Pee Wee's Playhouse, okay? There's proper form in this courtroom, that's how we're going to proceed. You allege the child didn't hear it, but the same applies with mother. Send me some money and I won't call the police the day you pick up C. You can at least spend time with her until you get arrested on your own. I mean, what are we doing here as parents? Both of you. I can understand being upset, and frankly, I'm upset because this minor child doesn't need to hear or see this. What examples are you setting for your child?
I set great examples, actually. In our household, we set great examples. We have routine, we have morals. As far as me and Candy not communicating, that's why I am here, because I've been denied everything. I always take the extra
old
initiative
is
to
she?
drop her off from school, like,
How old is he?
Sissy is 10 years old. She's gonna be 11 in March.
Let me explain how this works. I was a parent too. And I can tell you that when it comes to children, especially at age 10, heck is even earlier than that, much earlier than that, they soak up this stuff like a sponge. And sometimes they may hear it, they may not hear it. But I guarantee you that if a child is even in the periphery here, hearing this or seeing this, that affects the child the rest of his or her life, period. And there's no reason or justification for it. I get it. It's upsetting when you don't get the child when you're supposed to get the child. That I agree. I also agree with mother that it's hard to raise a child, especially with this day and age in our economy. And if you're not getting the support that has been ordered, it's hard as you know what to get the basic needs of these children.
I try my best. Look at all the other, as far as
Sir, I'm just
any
trying to
extra money I
explain.
do have, Your Honor, I try to send it to her as well.
I'm just trying to explain the court's position on this. And I've read the text messages regarding send me gas money, send me this, send me that. I've read all that. And frankly speaking,
Can that stop? I thought it was
Sir,
in our order
sir,
that we weren't
please-
allowed to do
please.
that.
please don't interrupt the court. If
Sorry.
I have a question, I'll ask you. But Mr. Curtis has a support obligation. He is to pay the support obligation. If the parties want to agree regarding gas or sporting equipment or whatever it may be, that's not support. Support is what is ordered by the court based upon your respective incomes and your respective overnights that you've had. So, with that understanding, and I understand the frustration. Don't get me wrong, sir. I clearly understand the frustration. But we have parents that frankly, just being kind here, do not get along, have a difficult time communicating. And it's got to stop. It just has to stop because this child's going to pick up on this and we're going to be in a situation where, God forbid, this child is before this court on a delinquency, for instance. Hope not. But they pick up on this. Now, moving forward, Ms. Lemke, why did the child go to father on the scheduled date?
Are you talking about, I'm sorry, are you talking about Christmas?
Yes,
I didn't want her, I wasn't sure how the bench warrant worked, and it wasn't something that I could really get a hold of the courts during that time, the holidays. But I didn't want her to be present with him if he were to get arrested. I thought that would be pretty traumatic for her to see her father get arrested. And it's not a good example anyways. And then knowing that you have a warrant, you're gonna be hiding out and you're not gonna be allowing her to go play, it's gonna affect her more. And I apologize. I did not follow court order. I did not.
I agree.
I know.
But to add insult to injuries, I mentioned a moment ago, when you sent that
Sorry.
text, send me some money that won't call the police the day you pick up C. You can at least spend time with her until you get arrested on your own.
Your Honor, she was at my parents' house. I honestly was just really frustrated. The voicemail put me over the edge. I didn't check it first before I played it. I thought it was gonna be something for our daughter to hear from him. And I have been telling her to call him and talk to him during that time. So I thought this was like a return call. I played it on voicemail without checking it first, and it really upset me because of what she said after. And that wasn't something, I was so angry. I thought, well, I am sorry. I just really just wanted him to be picked up by the police. I thought, this is your turn because you have done so much to me and there's a legal reason for you to be picked up. She was at my mother's. She wasn't going to witness it. I just wanted him to have some kind of consequences for it because it does put a lot of stress on us. It is very hard to feed these kids. And I know we're just considering the one that we have together, but it's very tough. And that support isn't something that's extra, it's needed.
Oh, I agree.
So I do apologize. I wasn't, I mean, money would have been cool, I guess, but I really just wanted to base a trust so that he would come and get arrested. She was not even there. She was at my parents' house.
Sure. Well, I find you in contempt for the denial of parenting time. As I read in the motion, it appeared that Mr. Curtis's father made the attempt to pick up. There was exchanges going back and forth, and there was no justification for it. I find you in contempt as well. What about the medication issue?
Yes, sir. Let's move on to that.
We'll address the sanction in a moment.
Okay, well, I guess. Well, on
You're
September,
alleging the child, you're not getting the full med.
I'm not getting that and all, yes.
That's
exactly.
one. And the second issue, as I understand it, is that you're claiming that the dosage increased without your knowledge.
Yes, absolutely. A lot of things are done without my knowledge.
Well, the one before the court is this one.
Yes, so on September 24th, you know, she knows I work. And even though I have a more lenient schedule than the 9 to 5, I still need time to make it to things. So September 24th, exactly what it says. I texted Candy if Seeley's doctor was located out at a specific address because her prior doctor, Dr. Christensen, he no longer, or his business was his business, is no longer so available there. So she told me the name of the doctor, Olivia Teal. And I asked if everything was her address. Candy did not respond for 2 days later. And then she responded with a text asking why I needed the address. So I felt like a lot of things was coerced. It was planned ahead that she didn't want me to be at this because we did not agree. I told her.
Well, according to the information you provided to the court, it appeared that stepfather was there.
Yes.
So
She
just to get to the brass tacks. Here. You're claiming the medication was increased and you had no input.
I tried. No, I had no input. I was
Okay.
not there.
Okay,
Yes,
hold it
sir.
right there. Miss, how do you respond to that?
We had a phone call over it about the medication,
Who's we?
me and Mr. Curtis, about having it increased, and he did agree to it.
No, objection, Your Honor, objection. Absolutely not.
It
She
was-
don't need it.
He denies that.
She don't need it.
It was,
Based on her
Wait,
report.
remember what I said? You deny it. I want to hear from you, Ms. Lepka.
it was just a verbal conversation. She stressed, and she did it on the phone with him too, that with Mr.
Who's
Curtis,
she?
our daughter, see?
Yes.
Explained to both of us on the phone that she was starting to feel like she was struggling a little bit with focusing in school. I had been keeping track of her weight to make sure that it wasn't affected by her medications, because this has been a trial and error thing for a couple of years now. This brand of medication has worked really well with her. She's able to eat, her appetite has increased, her weight has not dropped. We talked about increasing it the smallest amount, which was 5 milligrams up, and he agreed to it. I took her to her appointment. He should be able to figure out the address to the doctor himself. It
Did you
didn't seem
notify
like-
father of the appointment?
Yes, I did, over the phone.
Did you receive information? of the appointment?
Very, yes, and I will get to that. May I reiterate back to what she said about, yes, I am denying the increase. Can I explain that to the courts, please?
Well, you're denying it. I don't think we need more of an explanation.
Well, it's two different doctor opinions. One, I feel like the new doctor don't know her. Dr. Christensen was with her for years. I'm not-
That doctor is no longer practicing, right?
Right. Yes. Oh, as far as I'm concerned, he's gonna do house visits. I liked him as a doctor. She switched the doctor. We didn't agree on the doctor, but she switched the doctor because obviously he wasn't practicing, so that was out of the realm.
Your Honor, it was the doctor that.
She
it was
told
a-
me at 2, it was a 15-minute, what? I'm sorry. This is, I had very little time to respond when she said, it was at 2:15 or something. I think I had a couple hours to respond to the appointment and I couldn't make it. She told me that Jamie was taking her. She didn't even say that she was gonna be there. She said she had to work, actually, is what it was. She said she had to work that day. Jamie was taking her. Yep,
Okay.
so I had
I think
2
I think I've
hours.
heard enough on this issue.
Yeah.
Do the parties have that close?
That's another issue.
I thought that was
I
ordered.
do believe it's been ordered in the past, and I believe we've had hearings in the past of it not being used or issues with using it on parties' phone.
While you're looking, sir, have you been utilizing app close?
I cannot, because the last time we had, there was a technical issue. So I think we came to an agreement where text messages would be appropriate. If we look in the court order, I believe communication, because we have communication issues about me contacting my daughter as well on her time, or her contacting Celie anytime she wanted on my time, which was an inconvenience to us. So we set a certain time and date for phone calls and all that.
Do you recall that regarding app close?
I believe that what it was we were supposed to use that. We had fixed the technical issue while we were in the courthouse that day. We had to recreate, I had to recreate, at least on my part, a new email to go through for whatever issue it was. We were using it for a little bit and then Mr. Curtis failed to answer me back on it, and then only wanted to use text messages and phone calls. And at that point, we were actually getting along. Against my better judgment, I decided that since he would not communicate on that close, I wasn't gonna file papers because I'm just tired of going to court, to be honest. And I would just agree to whatever he wanted to communicate on.
Mr. Holman?
No,
That close has been stated numerous times throughout the file, with the most recent being the order modifying parenting time that was entered on March 27th of last year.
So app close is still according to the court order.
but if you look at it, she's seen my responses but never responded. So for her to say that is absolutely, it's
Well,
false.
here's how I'm gonna address the issue. The parties are utilize app close, period. No more texting, no more phone calls, because here's the problem with phone calls. Dad says, I never agreed to the dosage increase. Mom says, well, I called you and you said yes. A verbal agreement's not worth the paper it's written on. So I don't know. And I can't say I believe you or I believe you. I can't. So from this point forward, let's understand very clearly, and I'd like to state it in the order. The parties are to use at close, period. If there is a party that doesn't use at close for purposes of contact regarding the child, other than emergencies, obviously, then we're talking jail time for contempt. Do we have an understanding?
Yes.
No more. We're not playing these games anymore. We're looking at your child, and frankly, it's no disrespect to either parent. This court cares for the child. That's number one. And if both parents are fit to have the child, by golly, they have to follow the rules. Now, parenting time. You filed a motion for parenting time and custody?
Not custody.
Parenting time.
Yes.
What are you requesting regarding parenting?
Well, I'm requesting that Ms. Lemke has every weekend. And I have her Monday through Friday.
And it's week on, week off currently.
It's week on, week off, yes. Because of these issues, communication issues, everything she texts me, I thought we had an agreement in the order that it was for Sealy. Our communication between me and Candy is supposed to be for Sealy only.
Child,
It-
please don't use the child thing. Okay, I get it. You filed a motion regarding custody. What is the proper cause for change in circumstance?
The lack of medication being administered to our daughter. There is a note from the pediatrician that she currently sees that states clearly that she is to take it every day. I don't have that in front of me. Do you have it in front of you, Your Honor?
Well, it'd be hearsay anyway, but father's alleging he's not getting all the medication.
Your Honor, he is receiving the medication. I call to refill it every month. It's considered a controlled substance, so it has
Right.
to be ordered every month for the doctor. This month, she has to see the pediatrician in person before it can be refilled. This medication went on for an extreme shortage. I drove counties away just to pick it up. Mr. Curtis told me that he did not give it to her on the weekends. As much as we fought back and forth about the importance of daily, he would not give it to her on the weekends. I verbally asked him if he could take Monday through Fridays. That way, since he wasn't going to give it to her on the weekends anyways, that way there were the extra ones for the times that I had to wait a week to find a place to fill it and they had to call and order it. And he said that was fine. So I kept the ones he would not give to her. He would not give them to her on holidays, any school breaks or anything. There are times that this is going to be alleged anyways. I'm going to say it. At the last IEP meeting, teachers verbally told me that she,
Can't go to what,
Yeah.
can't go to what that, but let me ask you this. Let me ask you this so that we have a clear understanding.
yes,
I read in the file that you said in a text message that the school's going to administer the medication.
yes, Your Honor, I
did not agree on that either.
This was a decision I made at the last IEP that he did not attend. There has been so much misunderstanding and arguing between the two of us over her medications. And if she's getting it, if she's not, she's saying she's not. It's just too much. I just want to cut this whole problem out. The school has agreed that they will go ahead and administer the medication to her every morning that she's there. That causes a little bit of an issue when it's breaks or like, summer vacation. I want the school to take over that. That takes away a little bit of the stuff that we're gonna bicker about.
So does the school administer the medication when it's your week?
Yes, I have to refill this month. She has to have an appointment.
So all the medications other than weekends in school days off, other than that, the school's doing it all the time.
I will have them. I have to refill it. I was at work.
I do not agree with that. I like to give her
Sir,
medication
please.
in the morning.
Again, sir, I'm asking you politely, just a moment. Just a moment. I'm trying to get a feel for what's going on. And frankly, I've heard enough. So this is what the court's going to do. Regarding the motion for custody filed by mother. Number one. As well as the motion regarding parenting time for mother. The court finds that there's no proper cause or change in circumstance to warrant a review of the custody factors. Father's motion for parenting time, which really is a change of custody because the amount of overnights, the custodial environment would change. The court finds no proper cause or change in circumstance. That motion is denied. Regarding the violation of the holiday, court finds Ms. Lemke in contempt for failing to turn over the child as required. As a result of that, and how many days did you miss, sir?
You know, I haven't even counted because
Mr. Holdwick may know.
that,
I believe he had the second part of Christmas break.
Yes.
Because of his holiday, by policy, if makeup time was granted, it'd be like for like, just 11 overnights.
2 weeks, yeah.
But would be holiday for holiday.
And I'm ordering that as a sanction for that.
May I have that immediately? Because last time we had this problem, she did this 2 years ago to me. Same.
I made my ruling on it, sir.
No, may I
Miss
have,
Christmas, you're going to get Christmas now for this coming year. So,
It doesn't have to be
It doesn't.
Christmas. It can be any holiday he's not entitled to over the next year.
Oh,
He must
okay.
give advance written notice of at least 28 days to Ms.
Did you hear that?
Lemke in the
Yes,
front of
sir.
the court office.
That's what I'm going to order.
thank you.
That's what I'm going to order.
Okay.
Now, regarding the medications. I can't tell if dad said yes or dad wasn't involved because there's no verification of it. I'm taking both parties at their word. So regarding the medications, I am ordering that the parties are to dispense the medications to the minor child pursuant to the doctor's prescription. So if it is 10 milligrams every morning at 8, it is 10 milligrams every morning at 8, period. If the court finds out and evidence is established to indicate that the child is not receiving the medication, it can be proven. Just like I mentioned about APCLOS, now we're talking jail time.
Sure.
We're not playing games anymore. Relative to the issue of one parent saying, yes, we can give the medications or we can give a higher dosage. Again, I have insufficient proof regarding that. So it is required in APCLOS for every doctor appointment. I don't care if it's a dental appointment. I don't care if it's a physical for the child for purposes of sports or whatever it may be. Those appointments are to be placed in APCLOS, in the scheduling app, so that there is absolutely no question as to what's going on medically with this child. Regarding IEPs and all of that, I'm not ordering that both parties have to appear, but Mr. Curtis, if you're not appearing, it would be very important for you to show up. Okay?
I'm very
I'm
involved,
just
yeah.
suggesting that. I'm not ordering it, but that's how we proceed there. That takes care of custody. That takes care of the parenting time. We address both show causes. Is there anything I've missed from the parenting court?
I just want clarification, Your Honor, for the order on the show cause on the bench warrant. That with the payments Mr. Curtis paid and that the court acknowledges they paid that balance of that $21
Today.
today.
Yeah,
before the
today.
day.
He said he would.
Perfect. I know he said that. I just wanted to make sure for
Yeah.
that it was ordered. So that'd be it, Your Honor.
Okay.
Thank you.
Now, here's my final speech of the day. See that whiteboard? Both see it?
Yes, sir.
Okay. Clean slate. I'm starting with a clean slate. Both of you need to start with a clean slate. If you follow these orders of the court and have meaningful, closed conversations regarding this, I'm hopeful that we won't be back here again. Neither of you want to be back here again if there's a violation. Do we have an understanding?
Agreed, yes.
Good luck to both of you.
Your Honor. I shouldn't probably ask. I should
We're
just,
back on the.
I shouldn't probably ask, I should just probably be really happy that I heard nothing more, but as far as me being held in contempt, are we talking white slate here?
The contempt is that parenting time, he's getting makeup parenting time. That's the sanction.
Okay, I just want to
That's
make sure that I didn't have anything that I needed to do.
Not at this
Is it-
point.
Okay,
You don't want anything.
I don't
else
want to
do.
get in trouble,
No,
so
just follow the court order. That's all I want.
thank you, Your Honor.
Bench court is recalled too.
Thank you. I'm gonna pay that right now.
Thank you. Now,